Hello, Dawn Moore, Legence Title Company. I thought it might be worth a video to discuss what is required for you to act as an intermediary in a real estate transaction. I will suggest to you that most licensees understand that to act as an intermediary, you must first get a written agreement with your client. However, I find that many licensees forget that this written agreement must be entered into before you begin an intermediary relationship with your client. The contract showing the broker relationship to the parties in a transaction is not a sufficient written agreement for two reasons. First, it is too late at that point, and secondly, the License Act specifically states that an agreement to act as an intermediary must contain the following language in bold print. It must state that an intermediary may not disclose that the seller will accept a price less than the listing price unless the seller authorizes in writing to do so. An intermediary may not disclose that a buyer will pay more than the price offered unless the buyer gives written permission to do so. It says that the intermediary may not disclose confidential information unless authorized in writing to do so, or required by the License Act or a court order, or if the information relates to the condition of the property. It states that an intermediary may not treat other parties to the transaction dishonestly, and an intermediary may not violate the Texas Real Estate License Act. This required language and agreement are commonly found in the listing agreement and buyer's representation agreement. But what if you don't get your buyer to sign a buyer's representation agreement? Other than not having your buyer obligated to pay you commission in a transaction, you also don't have your buyer's agreement to act as an intermediary. In that case, you cannot negotiate on an in-house listing with your client, or you have to get some other written agreement from your client before entering into such negotiation. It is this discussion that usually gets a reaction from my audience when I teach agency law. I think many licensees forget about this prior written agreement requirement and go ahead and negotiate with their client on an in-house listing. Not only will TREC fine you for not abiding by the intermediary rules, but you are subjecting yourself to a suit from your client for misrepresentation and conflict of interest. If you abide by the intermediary rules, you will have a safe harbor protection from such conflict of interest suit. An easy solution to this issue when you don't have a buyer signing a buyer representation agreement initially is when your buyer wants to negotiate on an in-house listing, get the buyer to sign on a limited buyer representation agreement. Limit the buyer representation agreement to that particular property. Buyers usually understand when this comes up, this issue, and is willing to sign a limited buyer representation. Another point to remember under intermediary law, that if you are acting as intermediary only, you cannot give your client advice and opinions. You must simply act as a facilitator. However, if you are an appointed licensee, you may give your client advice and opinions. But you must remember that appointments must be made in writing, and notice of appointments must be given to both parties before you can give advice and opinions to your client. Without that, you cannot give advice and opinion and must simply stay in a facilitating position. Please also remember that no one licensee can be appointed to two parties in a transaction. Separate licensees must be appointed to each party when appointments are made. These intermediary rules can be an area of confusion for many agents, and I hope this video helps clarify and confirm your understanding of what is necessary to act in such a capacity. Hope to see you soon at one of our Allegiance title offices. Thank you.